Obviously, I am more cover at over daily update TV so. Yen name the Supreme Court at the ruling bar. Of late, I don't know more court ruling no 5-2 ruling no. That is a Supreme Court at no. Speaker Bagbin and the lawyer friend Tadia Sory. Uncle Pimo, but I say no. Tadia story. I release statement be I objected to the what Supreme Court ruling. Now, a religious statement and the to the Facebook or for credit ma a joy news or many copy key statement and ever coming with say there is an objection to the Supreme Court ruling. Now, men have a home and Casabe. You be call na joy news host no and for credit to more beam. Or backing kind, now be say objection Tadia Sory a raise against the Supreme Court ruling. I clear. And to be amica de bianca a speaker when him do obey. And that's on him the oil them. Oye. On him the oil them. And the way objection I hear Tadia Sory a speaker, lawyer Kesi. I release na a objection. Kesi and war praising. The Supreme Court. Engineer Supreme Court. Enyan in ye. Ashamono, either say it will move to the 9th Parliament, and that's the new Parliament that will be in 2025 Parliament there. But as it stands, this current Parliament there, Supreme Court Supreme Court Because they go see objection out there, but statement released to the time the Facebook wall. Joy News and for credit to mom be me and someone. So comment to comment section or more friend Vicent Echo as if for a old Tafo MP or no so no MPP Mrashe Bedreni or no so a can opinion to this objection that a Tadia Sory until way can be a good news to speak about it. We can be a celebration, we can be a joy moment because the lawyer Tadia Sory I release objection statement be a o catch and say Supreme Court I never be brave because and some omogena so fact basis or more release edibu asem no it was what not actually the fact. It is speaker must celebrate a good news because the objection from Tadia Sory no is clearly mean that the Supreme Court cook something. I'm saying you can go to a higher daily update TV. So subscribe and watch it. You made God bless you.
Parliament. That's the initial reaction of the Speaker of Parliament's lawyer Tadia Sory to the 109-page reasoning of the Supreme Court. The Apex Court said a member of Parliament is only deemed to have vacated his seat if he changes his political affiliation and continues to serve in Parliament under a new party identity. Well, coming up on your screens now are extracts of that judgment from the Supreme Court. It says, according to the court, a member of Parliament is considered to have vacated their seat only if they change their political affiliation while remaining in Parliament under a new party identity. The court clarifies that Article 97(1)(g) and (h) of the Constitution applies strictly to the current parliamentary term. These provisions are not relevant to future terms, such as when an MP decides to stand for election under a different party in subsequent elections. The court's judgment indicates that the constitutional provision in question are specific to the present term of Parliament, emphasizing that they do not address an MP's political choices for future election cycles. Well, shortly after the release of the court's decision, the Speaker's lawyer, Tadia Sory, took to his Facebook page to put up a write-up, sort of challenging the Supreme Court's ruling. Now, on your screens is the copy of that write-up on Facebook. He says, in every case before the court's final judgment is based on the case presented to the court contained in the original papers filed by the plaintiff before the court. The majority judgment unequivocally admits that at the time the plaintiff filed his case, the Speaker's response to the statement made by the leader of the NDC caucus in Parliament in capital letters had not been made. Darko Asare, the Justice of the Supreme Court, admits that the plaintiff instituted his action on the 15th of the 10th, 2024, and the Speaker made his statement on the 17th of the 10th, 2024. The plaintiff's reliefs, therefore, did not pray the Supreme Court to declare the Speaker's response to the statement null and void. So that's his major argument. He goes on to say, Darko Asare, who is Justice of the Supreme Court, who wrote the lead judgment of the court, therefore clearly admitted that there was no cause of action on which the plaintiff sought and obtained the order for the stay of execution. The effect of this admission also is that at all times, material to the judgment of the court, the plaintiff's case before the court disclosed no cause of action because the case was not formally amended to reflect the change of circumstances. He goes on to say that Asiedu also concluded his judgment by disagreeing with the Speaker when he stated thus, quote, "In my humble view, therefore, it is incorrect and unconstitutional for the first defendant to rule that the members of Parliament concerned have vacated their seats in Parliament just for the reason that they have filed nominations to contest as members of Parliament in the upcoming general election on the tickets of other than those on which they were voted as members of the current Parliament. It is for these reasons that I grant relief one endorsed on the plaintiff's writ." His final words, however, were that he only grants reliefs one of the plaintiff's reliefs. None of these reliefs to declare the Speaker's response to the leader's statement null and void. He goes on to say there is no order saying that the MPs must be allowed in Parliament or order directing that Parliament recognizes said MPs as earlier ordered by the court contained in the majority decision of the court. The order staying execution of the Speaker's ruling is now spent, he says. So this is a long write-up by the Speaker's lawyer, Sory. Let's bring in Member of Parliament for Tafo, Vincent Eko Asifo. He's also a lawyer, just to get his thoughts on this, some legal education. And I'd like my directors to put in the last paragraph of Sory read on the screen so that we could reference that. Educate us, because Sory's argument is that the court eluded an order, quote, saying that the MPs must be allowed in Parliament or an order directing that Parliament recognizes said MPs as earlier ordered by the court, contained in the majority decision of the court. I would like to find out from you, since the Supreme Court in its declaration that the Speaker's ruling and declaration of the 4-seat vacant is unconstitutional, was it necessary that the ruling indicated an order to Parliament?
Well, let me say a very good morning to you and to your cherished viewers. I just took my time to read what the senior colleague, learned colleague, Sory has written. And I can simply say that this is legal pretense. Legal pretense in the extent that the absence of an order will not make a declaration a white elephant. Put differently, the fact that the Supreme Court did not give an order does not mean that the declaration therein is ineffective. One thing that we should know is that if you remember the Abu Ramadan case, when the Electoral Commission at the time felt that there were no consequential orders that was directed strictly at the Electoral Commission, and for that matter, the Electoral Commission failed to act. The plaintiffs went to court again, and the Supreme Court proceeded to direct the Electoral Commission. So in effect, even if Sory, as a lawyer to the Speaker of Parliament, advises his client that in the judgment there was no order that was directed at him, and for that matter should not act, the plaintiff, in this case, Afenya Markin, can go back to court to go and seek for those orders. Number one. Number two, we should also understand that majority and minority is not a creation of the Constitution. And that is why I was expecting Sory to rather commend the judges for exhibiting their deep understanding of the constitutional arrangement. Because what majority and minority is just a creation, or if you like, a creature of Parliament, and not a creation of Parliament, the Constitution. So the Supreme Court, when it assumes its interpretative jurisdiction and assumes to interpret the Constitution, cannot interpret the Constitution where those elements are not creatures of the Constitution. So the Supreme Court could not have directed anything like the Speaker of Parliament in determining what a majority or minority is, but a declaration that I expect the Speaker of Parliament, and if you like, Parliament by extension, to use its tenor procedure to enforce that declaration. And so in my estimation, yes, there has not been an order directed at the Speaker directly, but it is expected that Parliament will use its internal procedure to enforce it. If Parliament fails, if the Speaker of Parliament fails to do so, what can happen is that the plaintiff will go back to the Supreme Court to ask for further orders or to ask for further declaration directed at the Speaker, which the Speaker will not have any option than to follow. But I don't think that we have to get to that point.
Now, another key point he makes in his write-up, he says, in every case before the court's final judgment is based on the case presented to the court contained in the original papers filed by the plaintiff before the court. If the facts on which the plaintiff initially presented their case to the court changes, they want the court's decision to reflect the changed circumstances. They must formally change the original case by way of an amendment. The Supreme Court rules allow the plaintiffs to amend their statement of case. Now he goes on to say, now the majority judgment admits that at the time the plaintiff filed his case, the Speaker's response to the statement made by the leader of the NDC caucus in Parliament had not been made. Sory admits that the plaintiff instituted his action, and he states the date on the 15th, and the Speaker made his statement on the 17th. Clarify for me the argument he's advancing here.
Well, whilst I agree to my senior colleague to a certain point, again, it is legal pretend, because we need to look at the suit in its entirety. In the suit was an interlocutory injunction, stay of execution, and what have you, which my senior colleague had the opportunity to respond to some of them. Now, in the ex parte application, had it not been the fact that the Supreme Court, the Speaker of Parliament, even though at the time that he was giving his declaration, the suit has already been filed 2 days before, where there has not been any positive act or omission, which means that the suit was not properly before the Supreme Court. Had it been that there was no further action from the Speaker of Parliament, I would have agreed in its entirety with my senior colleague. However, lawyers will tell you
So I daily update TV. So then I will share and subscribe and I'll share Jubilate na mo nyo be na onyo be so nsa ka bi. Daily update so na wo sugusu a ohwe. Ni nyina ye Supreme Court nsam Tadia Sory e de nsam aba. Objection akese in the koso. Because the way and 70 connection source of share comment in God bless you.